When the Supreme Court ended the constitutional right to an abortion last year, the headlines were stark. States were now free to ban abortion, and the whole country was about to undergo a seismic shift in terms of basic freedoms. But there were additional headlines around that time that were worth paying attention to because the fallout from that Supreme Court decision did not stop with abortion. Here's the NBC News headline from that time. Justice Clarence Thomas wants the Supreme Court to overturn landmark rulings that legalize contraception and same-sex marriage. In his concurring opinion, in which he voted to strike down Roe, Justice Thomas also argued that the court should not stop there. He wrote, "In future cases, we should reconsider all of the court's substantive due process precedents, including the case that legalized gay marriage, because any such due process decision is demonstrably erroneous, and we have a duty to correct the error established in that precedent." Justice Thomas was essentially arguing in that Supreme Court decision that legalized gay marriage was wrongly decided and encouraged someone to bring a new legal challenge to the court, one that would give the court the opportunity to correct the perceived error and allow states to dismantle marriage equality. And it did not take long for someone to start going down that road. Late last month, the Supreme Court ruled in favor of a Colorado web designer who had refused to design wedding websites for couples who are gay. Now, even though the law requires her and her business to serve everyone equally, she argued that the law was forcing her to advance a message she doesn't believe in. And the conservatives on the Supreme Court agreed with her. They ruled that this woman had the right to discriminate against same-sex couples solely based on their sexual orientation. And already, this case, the one with the web designer, is paving the way for others to challenge not just the right for gay couples to hire a web designer, but exactly what Clarence Thomas encouraged last year, to challenge whether gay couples can get married at all. In 2019, a justice of the peace from Waco in Texas was given a public warning after she refused to perform gay marriages. After receiving that warning, she sued the state panel that sanctioned her, saying they violated the free exercise of her religion. That case has been making its way through the courts ever since. And now, given the recent rulings from this conservative Supreme Court, this judge seems to have a stronger legal leg to stand on than she did when she first brought this case back in 2019. The Justice of the Peace has filed a new brief to try and bolster her case, in which she specifically cites the most recent Supreme Court ruling about the Colorado web designer. In her brief, she argues that the same rules the court applied to this web designer should apply to her, a justice of the peace. If the web designer is allowed to refuse web design service to the gay couples, then she too should be allowed to refuse gay marriages. And this justice of the peace is clearly speaking directly to her audience. She says she fully expects this case to go all the way to the Supreme Court of Texas. And we all know what court comes after that one. This is one to watch. Joining us now is Charles Coleman, former Brooklyn prosecutor and current civil rights attorney. Charles, thank you for making your debut on Alex Wagner tonight on this very distressing series of legal events. First, your reaction to this Justice of the Peace and her filing. She clearly sees an opportunity based on the ruling in Dobbs. Is she right to see an opportunity?
She's not right, but she's not surprising in this way. After that decision came out in 303 Creative from the Supreme Court, I predicted that we would see a number of different challenges across jurisdictions because the way the ruling was issued was very, very technically hairy and nuanced. And as far as I'm concerned, reading that and making the comparison is apples to automobiles. You're talking about someone who is a state employee. She is a government employee, so she is not a private employee.
She's
like
not a web designer.
Correct, like the web designer. That's number one. That's important to understand. So the laws that govern there are very, very different. And then you're also talking about a First Amendment analysis in the 303 case versus a state law in Texas that you're trying to apply to basically expand that far beyond anything that the Supreme Court of the United States actually said. So in terms of the pathway that she has legally to get where she wants to go, 303 Creative does not apply. Those cases are not relevant in that way. in terms of principle, even that is misinterpreted in terms of what 303 Creative actually says. But, Alex, this is not going to be the last time we see this sort of challenge around that Supreme Court ruling.
Well, I mean, I totally agree with you, if only because Clarence Thomas has said effectively, explicitly, hey, anybody want to dismantle gay marriage? Bring a case to me. Bring a case to me. And there have been so many instances where it looked like the plaintiffs didn't have standing, or you couldn't imagine that the Supreme Court would actually take this up, and yet they do, because the Supreme Court, at least the conservatives on the court, seem dead set on furthering a specific agenda. Do you think there's a chance that Clarence Thomas looks at this case and says, maybe we can get it up here?
I don't necessarily know that it matters whether it's this case. The idea, as you've already said, and I'm glad you brought up the point, is that he's made the invitation. He has fired the very loud warning shot to basically say, we're open to reconsidering these things. And so what that does for litigants across the country is that it emboldens them. These sorts of decisions, Alex, occur over the course of a lot of time, as we saw with Dobbs and how Dobbs dismantled women's reproductive rights in America. They are subtle victories here and there, small cases that you basically stitch together to create a larger legal theory that you then find the perfect case to put before the court. You're not always going to win those cases. Look at affirmative action. That took so many losses before they finally got the win that they wanted. But with this invitation from Justice Thomas, what he has said is, hey, get them ready. We'll take a look, and you may be able to start moving along in the strategy that you want.
Well, and it's reminiscent of what happened with abortion. And by the way, Jonathan Mitchell, the former Texas Solicitor General, he's the sort of architect of the 2021 Texas bounty hunter law that encouraged private citizens to sue people involved in abortions. That wasn't ultimately the case that the Supreme Court took up to dismantle Roe, but it was part of this groundswell, to your point, of anti-abortion cases that were sort of winding their way through the courts. He's also the guy that's involved in this gay marriage lawsuit down in Texas. And I guess to your earlier point, I mean, he is one of those foot soldiers that helps sort of drum up the field army, if you will, to get this thing up into the highest court in the land.
So you have this agenda that's set forth in large part by Christian nationalists, and they're pushing it. And this is the arena in which they have different people, the legal arena, the courts, that they're looking to enact certain laws and enforce certain decisions by the court that are going to reinforce what it is that they're trying to do with their agenda. And he's taken every element from different aspects and tried to move it further and further and further. And my thoughts when the 303 Creative ruling came down was, people are going to continue to push these boundaries. It just so happens that he's doing this in Texas, but this is going to happen throughout the country with respect to people seeing how far they can go with respect to denying services and opportunities to same-sex couples or anything else that they are going to claim is in conflict with their religious beliefs.
Well, and wait till we see what happens in and around affirmative action and the after effects of that. Yikes. Charles Coleman, thank you for your time. Thank you for your time on this Friday night. I appreciate it.